I'm Jake Blight, the Independent National Security Legislation Monitor, and I'm joined in this session again by my Principal Advisor for this review, Anita Coles. I'm also joined in this session, I'm very glad to say, by Gillian Siegel, Australia's Special Envoy to Combat Anti-Semitism, and Anita Stucken, also from her office, Peter Wertheim and Simone Abel from the Executive Council of Australian Jewry. I acknowledge that in the wake of the terrible attacks in Bondi, it's still a particularly difficult time for many Jewish Australians and a hard time to be talking about terrorism. I thank you all for being willing to engage constructively with this review at this time, and for your submissions and for the engagement I've already had with all of you recently and for your earlier engagement with the review. Simone, I understand you'd like to make a brief opening statement on behalf of the Executive Council for Australian Jewry.
Thank you very much. Monitor and Principal Advisor, thank you so much for the opportunity to appear today. The ECAJ is the national peak representative body of the Australian Jewish community with over 200 Jewish organisations under our umbrella. We are pleased to appear today alongside Australia's Special Envoy to Combat Anti-Semitism. As the recent anti-Semitic terrorist attack targeting a Hanukkah celebration at Bondi Beach demonstrates, terrorism seeks to challenge the very nature and existence of our society by targeting places of symbolic importance and fundamentally undermining our collective sense of safety and freedom. Terrorism is today the most direct asymmetric threat to the security of individuals and to democratic societies generally, and to international peace. There is something very unique and different about terrorist acts. They strike at the heart of our society, and they are capable of being differentiated by their intent, motivation, and targets. The motive element to advance a political, religious, or ideological cause must be retained. It is the key component of what makes terrorism distinct from other types of crimes. Every major allied framework, including the laws of the United Kingdom, Canada, the European Union, and New Zealand, retain this element. The current law is fit for purpose and neutral. Unfortunately, the facts speak for themselves. Of the 83 sentencing decisions and appeals for persons convicted of terrorism offences under Section 80.2c and Divisions 101 to 103 of the Commonwealth Criminal Code from 2002 to 2024, 78 were cases where perpetrators were religiously motivated. Of the remaining cases, 4 involved perpetrators motivated by white supremacism or right-wing extremism, which was ideologically based. That is to say, in all but one case, the perpetrators were motivated by extremist religious or ideological frameworks that are infused with anti-Semitism. Perhaps more than any other community in Australia, the Australian Jewish community has faced a long history of sustained terrorist threat. This has included significant violent and life-threatening incidents and serious damage to property, including the 23rd of December 1982 bombings of the Israeli consulate and Hakoah Club in Sydney, which the Coroner's Court of New South Wales found in 2022 were an act of international terrorism. From January to March 1991, during the Gulf War, there were a series of arson attacks targeting Jewish institutions in Sydney. 5 synagogues were targeted, including a kindergarten attached to one of them, with 4 sustaining substantial damage. More recently, in late 2024 and early 2025, there were a series of high-profile anti-Semitic incidents in New South Wales and Victoria. These included the destruction of a childcare centre by fire, the attack and fire on property outside the ECAJ's co-CEO's former home, and what seemed to be the attempted destruction of Newtown Synagogue by fire. ASIO has declared that 2 of the attacks were terrorist incidents. This demonstrates that concerns about the definition of terrorism being too wide are misplaced. Terrorism remains a very substantial threat to the Australian Jewish community. We support the current legislative framework, and we view it as necessary to protect the public order, community safety, and the equal participation of all members of the Australian community in public life. Thank you.
Thank you very much, Simone. I understand that Ms. Siegel didn't have an opening statement, so we might just pick up on a couple of threads that you've raised in your opening statement. Let's begin with property. You've given some examples of attacks on Jewish property or Jewish-owned property there, and I think it's generally accepted that damage to property, like bombings that endanger life or cause serious harm to people, should be and should remain part of Australia's definition of terrorism, and that's also the international position from the UN Special Rapporteur. Where Australia seems to be somewhat out of step with international norms is including serious damage to any property in the definition, regardless of whether there's a risk to people. In advance of this hearing, I sent you a possible way that Australia's property element could be redefined. We've already had some discussions about that in other sessions in this hearing. But I wanted to get your views on whether that is a proportionate approach to property damage alone in the definition of a terrorist act.
Well, perhaps I could address that, Monitor. And perhaps it's best addressed by giving a concrete example. One of the incidents that was deemed to be a terrorist incident by the federal government was a firebombing of a kosher catering establishment in Bondi in October 2024. Now, this is an establishment that has no cultural or religious significance. It just happened to be a business that dealt in kosher food, providing kosher food to the local community. And it was a business that had been around for more than 60 years. It was deemed to be a terrorist incident because it was, according to the government, it was orchestrated by the Islamic Revolutionary Guard Corps of Iran. So it was undoubtedly a terrorist incident, and worse than that, it was a state-sponsored terrorist incident. So this is an example of an establishment that did not have cultural or religious significance. There was nobody around at the time. The property is sort of on a corner. It's quite set apart from any other establishments. There's a golf course on the other side of the road. There was no possibility of serious harm to people that could be proved beyond reasonable doubt in the particular circumstances of that case. And so we say that's an example of serious damage to property. It actually ended up putting this long-established business out of business. And of course, it had a huge impact on the Jewish community because not only was it deprived of a long-standing establishment that provided for the kosher needs of a section of the community, but it was also quite clearly intended to strike fear into the local Jewish community, to let it know that, to send a signal, as it were, that it was being targeted as such. So for these reasons, we think that the current definition should be retained. It would capture an incident like that, and introducing new qualifications to make it harder to prosecute, we think, in those circumstances, would be unjustified.
Could I just clarify, Peter, that matter, I know you said it was investigated by counter-terrorism police. Is it still before the courts, or has that matter been finalised through the courts? Was it prosecuted as a terrorist incident?
No, it was named by ASIO and the federal government together. From memory, it was a joint press conference as an incident that had been orchestrated by the Islamic Revolutionary Guard Corps. The people who were actually involved in the act of arson, through which the terrorist motive was manifested, I understand is still before the courts. It's possible that some have been sentenced. I haven't got up-to-date information about that, although it could be easily obtained. However, it's important to understand that there were several layers of command, if I could put it that way, in the way this was orchestrated. And the people who actually carried out the incident, from their point of view, they were just local criminals, possibly paying off drug debts or some other purpose particular to them, who would have been completely unaware of the origin of the decision to target this particular venue. I might add that they had two goes at it. There was an earlier arson attack on another establishment in Bondi Beach called the Curly Lewis brewery, which the criminals had mistaken for the target that they had been instructed to attack. And so after that aborted effort the first time, they were told a second time where to go and given more precise instructions. So again, we had an establishment that had nothing to do with the Jewish community being attacked and being the subject of property damage, but nonetheless being part of that whole criminal and we would say terrorist enterprise because of where the orders were coming from.
I think if I might add, I think it was not prosecuted as a terrorist act because of the fact that instructions were given by somebody who was not being prosecuted, and the people who actually conducted the act, the police obviously decided that they couldn't prove the terrorist motivation. But can I just say I totally endorse the position that that changes should not be made to the current definition of damage to property, serious damage to property, because it would be effectively narrowing the definition. And what we are dealing with here is an example of a terrorist act, terrorist motivated act to instill terror in the community, and that is what happened. And to merely narrow the definition at this point in time, and I'll talk a bit further about this later when we come to talk to the intent aspect, it seems so counterintuitive that as we see more and more terror and more terrorism being exhibited in the country, that we should be narrowing the definition. So I totally endorse ECAJ's view that it should not be narrowed and require harm to people. Damage to property can be just as terrorising to a community.
I think that's clear. One area where you have suggested expanding is hostage taking, and I know Anita's got a question on this.
Yeah, so I just wanted to check with you. So the Attorney General's Department, who we're hearing from later, in their submission they said that, so currently the list of harms doesn't reference hostage taking, and they have said that hostage taking isn't necessary to specifically include in the definition because it's probably already covered by the list of harms, such as, you know, if you take a person hostage, it's likely to create a risk of serious harm, and it's already an offence under other laws. You have said that both of your submissions have said hostage taking should be listed separately. Could you explain why you think it's necessary to separately include hostage taking in the definition of a terrorist act?
Well, firstly, the Convention against the Taking of Hostages, the International Convention to which Australia is a party, itself refers to hostage taking as a manifestation of international terrorism. That's not to say that every example of hostage taking comes within that category, but it is one species of terrorism, and that is recognised in the Convention itself, in the recitals. So we think that even though hostage taking is an offence in its own right, as it should be, where it is connected with a terrorist motive, it should be recognised as such. It should carry more severe penalties, and there should be consistency between the international convention to which Australia is a party and our domestic law.
So you disagree?
Sorry.
Did you want to add to that, Ms. Eagle?
I was going to say I totally agree. I think that obviously it's a very serious offence, but as we've submitted previously and as we've discussed, having it as a terrorism offence allows greater powers of investigation as well as then ultimately penalty. And I think that using hostages, as we've seen, I mean, it wasn't in Australia, but we've seen the whole issue in the Middle East, is a tactic of terrorist organisations and should be very strongly discouraged. And this is, including it, would send that extra strong message. And I think that what we have to understand when dealing with the law, and I'm sure you do, but I'm just stating it for the record, is that it sends the message in society as to what we think is absolutely unacceptable. It puts the barriers, the side barriers as to what path people can follow in our society. And any indication of weakness or change that indicates weakness, is going to encourage behaviour that we don't want. And similarly, on the other side, clarity as to what is totally unacceptable is what makes for a strong democracy.
Thank you.
Thank you. Area where you've suggested expanding is mental harm. And I just want to, for the record, be clear that there's no doubt that those who are attacked by terrorists, along with their families, friends, first responders and others, are likely to suffer mental harm from the attack. And as we heard from Louisa Hope yesterday, a survivor of the Link Cafe attacks, that can be lifelong. So the question for me is not whether that mental harm is real or should be acknowledged. It is and it should, and it's already taken into account in sentencing. But I am considering whether serious physical harm should be amended to include serious physical harm or serious mental harm. And in effect, this would create a new category of harm in cases where there was no physical harm to any person or no risk to life, no damage to property or a threat of any of those things. We just heard from the Right Reverend Michael Stead that he's concerned that mental harm should not be included because it may inadvertently capture some religious teachings and that they shouldn't be brought within the definition. And we heard yesterday from civil liberties groups who are concerned about the expansion of terrorism laws. I just wonder whether you'd like to comment on this. And I note that one of the examples in the ECJA submission was about the Opera House protests in 2023. It's not clear to me whether you're proposing that kind of Opera House, grossly racist and threatening behaviour should be within the definition of terrorist act, or if you're making a different point there.
Well, I'll let Simone speak to the Opera House incident, but just on the general principle, I respectfully disagree with my friend, Reverend Stead. We are not talking about arguable mental reactions to a particular situation. I think the proposal being put forward is one of serious mental harm. And by that, I understand the reference is to a readily diagnosable and provable form of damage, which is every bit as real and sometimes even more devastating than physical harm. So it's our position, Monitor, that the definition should allow for a situation like that to occur. Putting aside the Opera House example, just taking another example, we were talking about hostage taking a moment ago. There might conceivably be a situation where there was a hostage taking situation in a terrorist context by a group of terrorists seeking to impose their particular views about what governments should or shouldn't do or how governments should be organised, and using hostage taking for that purpose. Even if there is no provable risk of harm, physical harm to the people concerned, it's quite clear in a situation like that that there's going to be very serious psychological harm or a very high likelihood of psychological harm of a quite profound nature. And so, again, I think it's important that our laws reflect the reality that we are confronted with, and that the proposal to expand the range of harms that could be encompassed by the terrorist offence should include serious psychological harm, even if that's accompanied by some sort of explanatory note as to what that is intended to encompass, to perhaps exclude I think the rather remote possibility that Reverend Stead was talking about.
Thank you. I should have also said in my introduction that you're not the only group who's proposed this. Equality Australia yesterday raised targeted psychological harm against LGBTIQ+ community members as an example. I should have mentioned that in my introduction, that there are others who've suggested this as well. Sorry, Simone, Peter, did you want to say more on that before I turn to Simone?
No, I was just going to say the example from Equality Australia is a very good example in my humble opinion. I respectfully agree with it.
Thank you. Sorry, Simone?
Yes, I just also wanted to endorse that example by Equality Australia. I think that's really pertinent. I know that we have previously talked about aviation offences and the separate regime for that, but if we look historically at some of the more severe terrorist attacks or acts that have been inflicted against Jewish communities around the world, for example, the hijacking of aeroplanes, the Layla Khalid incident, there's not necessarily always serious physical harm inflicted on the victims, but televised worldwide, and similarly with the Linz siege, the ramifications of those sorts of acts are very, very far-reaching, and it would seem to be artificial to exclude those kinds of acts from a definition of terrorist act. Just because they didn't lead to serious physical harm to the individuals. I think, if we were to expressly include hostage taking within the framework, I think that would go quite some way to addressing this issue around psychological harm. There's many ways in which we could potentially include psychological harm without necessarily having something that's unreasonable or too far-reaching. But I think that we do need to recognise that with terrorist acts, they actually inflict damage that goes well beyond the physical harm. And I had the pleasure of meeting Louisa Hope last week and speaking with her about her experience at Lynn Cafe. And I think we can't really underestimate the intergenerational impact of acts like that on Australian soil. It goes so far beyond what happens to the victims and the family members. I mean, this is something that we are still, as a society, I think today, grappling with. Similarly, 9/11, the ramifications are so serious, and those ramifications go vastly beyond the physical harm inflicted. And I think that we do need to recognise that.
And I think if I could add, if you look at what you referenced, Monica, the Bondi killings, well, obviously the people there suffered physical harm, but their families who were not there, members of their families who were not there, suffered, serious psychological harm. If I could add, I realised the special rapporteur had recommended against including mental harm. And one of the points that was raised in their submission or their report was challenges in the criminal arena in proving mental harm. But can I say I challenge that, because today, with the developments in psychology and the work that's gone on there, and in other areas, for example, in the military area where I have some prior history, and it's become a very important issue in terms of establishing if there's been a cause and effect in relation to serious mental harm and what benefits those soldiers or veterans achieve or are allocated. And so here we have had developments, and it's such an important part of a terrorist act actually to cause that intimidation, that it should be recognised in the offence itself.
And Monica, may I just add as well, a very recent example I think that illustrates this really well is what happened on the 26th of January at that rally, which I think instilled fear in the broader Australian community and certainly in First Nations Australians, with the attempted attack. And again, the psychological harm of that, it has a really chilling impact. People may be less inclined to congregate, to exercise their democratic rights, etc. So I think we just need to understand that this impacts many communities. This is not just about the Australian Jewish community.
Yeah, and it's part of the intent of a terrorist to have that impact. So we need to recognise it in the offence.
No, thank you. That's a good point. I mean, those are all horrific examples where people do indeed suffer prolonged and serious mental harm. And as you say, intimidate the public is part of an element of the purpose clause. I think I might go now to the more perhaps difficult issue, and one that I know you want to speak to, around ideology and religion. One of the things you said earlier was that the motive element should be retained, and it's a key distinguisher feature of terrorism. I said in my opening statement yesterday that I'm inclined to agree that motive element should be retained as a key feature, though I'm still yet to form recommendations. And of course, at the moment, that motive is to advance a political, religious or ideological cause. And I've discussed some concerns about how that definition is more challenging in cases of neo-Nazi, white supremacy groups than it is in what you might call the archetypal or traditional terrorism, which is 80 or more, a very large percentage of the cases we've had. Before we go into the topic of whether a religion is an ideology, we'll definitely come to that. I just want to focus on ideology, and particularly whether you think the proposed definition how it may apply to groups that are, white supremacist or neo-Nazi driven groups. Do you have any thoughts on that before we come to the religion question?
Well, I think the definition you proposed, Monitor, would extend to white supremacist groups, because it would encompass any organisation or any attempt to impose a particular view about how society is or should be organised on the rest of the community. And I think that is the essence of terrorism. It's there to impose the will of particular individuals or groups on the great majority. The difficulty that we have with the proposed definition of ideology is not so much the reference to beliefs or ideas, it's the use of the word system, which implies an interrelatedness between those beliefs and ideas. Now, often where you have a well-developed ideology, the word system might have some genuine application. But with these days, with more and more outlandish memes and ideologies being generated, particularly online, the interrelatedness of those beliefs and ideas may be more in the imagination than in reality. So we would suggest, with respect, Monitor, that instead of the word system, you might consider the word group, a group of beliefs or ideas which are or are perceived to be related to each other. We think that that would capture the current diffuse and often self-contradictory nature of the beliefs that drive terrorism in the contemporary world, and put that to you for consideration. But yes, there's no question that neo-Nazi activity should also come within the ambit of any definition of ideology that is being proposed.
And could I endorse that, Monitor, that obviously far-right terrorism should be included, but we had exactly the same issue with the word system, and that system does try to convey something that was coherent, and indeed a group of beliefs that might infect somebody with or inspire them to commit an act of violence may not always be coherent. And you don't want to fall into the trap then of failing to capture an act that is influenced by those ideologies, but that is a bit of a branch out of it or whatever. System is too organised, conveys too much organisation and interlinking. So I do like Peter Wertheim's suggestion.
If I could just add, Monitor, I accept that the definition being proposed doesn't necessarily require there be coherence, but it does require that there be some degree of interrelatedness. And it's that interrelatedness that I think is the issue, because often we have found that there's an interrelatedness in the minds of the people who are propagating these ideologies, but it's in their imagination, it's not in reality. And so if a prosecutor was confronted with the task of having to establish the interrelatedness. They would have difficulty doing so on objective evidence. So that's why we suggest a perception of interrelatedness as something to be built into the definition.
Thank you. That's very interesting. I would definitely contemplate that, and I do agree, or not. It's not my intent to say that it would need to be a coherent system of beliefs. I would never want to suggest that neo-Nazism or any of those kind of things are coherent. I take your suggestion on board. I will definitely think about that. Thank you for raising that and those alternative ways of approaching it. Just checking whether Simone or Anita or anyone want to say anything else on ideology before we go to the question of religion. Simone?
No, thank you.
Difficult issues, and I know one that you feel strongly about, and I want to allow plenty of time for you to talk about. It is my intention that a proposed new definition of ideology would be drafted in a way that leaves no doubt that the word ideology, for the purpose of that definition, is intended to include religious belief systems. And I raised this with a number of witnesses yesterday, including legal experts from the Liberty Victoria, academics, Law Council and the DPP, who, though they would of course need to see a drafted version, don't see any principled problem with a proposed definition covering religion or any real doubt that it could be achieved, though they did suggest, particularly the Law Council, that any doubt would need to be resolved through the explanatory memorandum and possibly a note to make sure that it's clear that Parliament's intent would continue to be that it was capable of covering secular and non-secular belief systems that are claimed or perceived, and as you've said, not necessarily coherent ones. However, I think your submissions make clear, and your submissions were before I provided you with the draft, though before I developed the draft and before we had the benefit of that evidence. As I understand your submissions, you don't think ideology is able to be defined in law in a way that includes religion. And I wanted to provide you an opportunity to clarify or to speak to that now. Peter, do you want to go first on that?
Yes, thank you, Monitor. It's our position that the concept of ideology does not do justice to the concept of religion. Ideology, as your suggested definition implies, is focused on the way society and politics are organised, or in the mind of the perpetrator should be organised. It is very much focused on human society and the realities of human behaviour. Religion, in contrast, is something much broader to that. Broader than that. It's not just about beliefs and ideas. It's about doctrines, tenets, teachings that are not even theoretically open to debate because they are divine imperatives. They are beliefs not only about the way society is or should be ordered, but about the universe, the cosmos more broadly, and about human nature and the human soul. So the content of religious beliefs is fundamentally different in both focus and intent to that of ideology. And so rather than blur those distinctions, and particularly in a context where, as Simone pointed out earlier, 78 of the 83 cases that have been recorded have involved religion, we say that that distinction should be preserved. It should be made very clear what it is. It's not directed against any particular religion. The way it's framed now, it is simply recognising that religion is somewhat in somewhat of a different category to ideology because of its content, its focus, and its preoccupations. But above all, because it is not even theoretically amenable to rational argument. One can have arguments about the way society is or should be ordered, and even allowing for the fact that terrorists are often acting out of irrational motives. there is at least a theoretical possibility of a discussion about those issues. With religion, because we are talking about ideas and beliefs that are supposedly divinely mandated and about the universe at large rather than human society in particular, there is no room for rational discussion. So it's a very important tool that is available to our law enforcement and intelligence agencies at the moment. And it's something that we can ill afford to lose, and it's a distinction that should not be blurred in the current climate in particular.
And I wonder if I could just totally endorse that and make two small additional comments. And that is, I do not believe that your proposed definition of ideology makes religious a redundant term. So you asked that question as, sort of the legal issue, and for all the reasons that Peter has just articulated. Extreme religious beliefs may concern something as specific as just a divine command and not be part of any broader system that relates to society or anything like that. But your second question is the policy question, and you spoke about the legal analysis and any particular note that might be written by Parliament, etc. The policy question to me is the key, and it should not be changed at this point in time. We've had, as has been articulated, 78 religious motivated terrorist crimes that have been recorded, prosecuted. We have a body of precedent, understanding of the way these terms are distinct. To change it at this point in time, when we have examples of considerable rise of terrorism in the country and terrorist threats, if not terrorist acts, would be, I think, a very bad policy outcome for the country, and particularly for minority communities that have been attacked, not just the Jewish community, but the LGBTIQ community and the Indigenous First Nations community. So I would put to you that from a legal perspective, I think it's definitely not clear and not easy, and creates a gap where people can talk about the fact that they were not ideologically motivated, but they were religiously motivated, and it's not included in your definition. But from a policy perspective, I think it would be extremely regrettable to do that at this point in time.
Monitor, may I just offer one more kind of point on this, which is to say that ASIO's terminology distinguishes between ideologically motivated extremism and religiously motivated extremism. And I think that disbanding that distinction is problematic. I should also say, in my previous work before ECAJ, I provided legal defense to individuals charged and convicted of terrorist offences, including religiously motivated ones. And the thing that I would say is that there is a body of evidence that the way that you approach de-radicalisation of individuals who've been religiously motivated versus individuals who've been ideologically motivated is different. It has proven harder to de-radicalise individuals who are religiously motivated. And I think that if we, that sort of points to this underlying issue, which is that there is something very much more ingrained and innate about religion that makes it a different phenomenon. And so we need to treat these things differently, because as a society, we have to find ways to respond to them, and those ways need to be nuanced and effective.
If I could just add one more point, Monitor. Motivation, by definition, is very subjective. And so I think we should be loath to try to substitute some preconceived idea of other people's motives when they themselves are very clear about what their motives are, and especially when it's a religious motivation. There's no doubt in their minds what it is and how it should be categorised. And to try to substitute some external understanding into a religious belief system or culture that we ill understand, I think is fraught with hazard.
You've made very clear legal and policy statements and position there, but I also wanted to give you a chance to respond, if you have any comments, to those who say that they see harm in retaining the word religion in the definition because of the way it has affected a range of things in the last 20 years. The UN Special Rapporteur, for example, felt that the stigmatisation of minority religious communities outweighed any risk of removing the word. We've heard from academics, civil liberties groups, Christian and multi-faith groups about their concerns about the negative effects of the word religion remaining in the law. I just wanted to provide you an opportunity to respond to those comments.
Well, I think the stigmatisation they're referring to, which I think is real, arises out of the characterisation of these atrocious acts by the perpetrators themselves, far more than the fact that they are then investigated and prosecuted for those acts and for the motivations they themselves have ascribed to those acts. That's where the stigmatisation originates from. I don't believe that anyone's come up with any study to differentiate between those two sources of potential stigmatisation. And just to repeat, this is not directed at any one religion. It's quite obvious that acts of terrorism can be carried out by people for a whole variety of reasons, and that includes a variety of religious motivations. It just so happens that in recent times, and especially in the last 20 years or so, that this particular form of motivation, a very extreme and violent form of religious motivation that has been ascribed by the perpetrators to Islam, has been to the fore. Prior to that, the other forms of terrorism were much more prominent, and none of these issues arose. I just don't think that we should be trying to politically massage the reality instead of dealing with it.
And can I say I agree with that? Absolutely. And I think that's very well put. And also, Monitor, if you were to engage in a massive exercise of drafting to try and put religion inside ideology, you would have to mention all those issues that relate to religion in order to be absolutely confident. And I think that would not solve that problem of specificity, because you'd have to specify enough of it for it to be clear. So much better not to go through that exercise, not to give in to the political issues of where we are today, but to look at it over time and over history and over where we want to protect the community more generally, and to leave it as it is with the clarity that it has and the precedent that it has for police and prosecutors and the judiciary. Because whenever you make a really significant change, I think that it throws up, from a policy perspective, serious concerns.
I might add one more thing, Monitor, just on that point, and that is to try to blur religious motivation by subsuming it within a broader ideological definition, I think is only going to invite public scepticism and perhaps an even higher degree of stigmatisation or negative reaction than already exists. I don't think, in short, the public's going to buy it.
Thank you. I think your position is very clear there. I don't have any more questions on that, but I do want to provide also an opportunity. We've got another few minutes. If there's anything else you want to say either on this topic or any others that I haven't touched on or asked any questions about that you particularly wanted to raise from your submissions. Peter, is there anything you wanted to add? I'll go to you first.
Nothing further. Thank you, Monitor.
Did you have anything that you wanted to add to what Mr. Wertheim had said?
I don't think so, other than to emphasise what was said in their opening statement. If I could just re-emphasise that obviously we are worldwide in some difficult times, but particularly in Australia, and as it has affected the Jewish community and other communities. I mean, we've seen potential terrorist acts or acts that have been categorised at the moment as potential terrorist acts against other communities, in the First Nations communities and the LGBTIQ communities. So that is a worry, because it's terrorism against 3 minority groups already in our society. And as a multicultural country, we're actually made up of lots of minority groups, not just those 3. And each minority group is going to fear an attack at different times, as we've seen. Different communities have been attacked at different times. And even large communities, like we've seen the Asian community attacked at the time of COVID. So I think one mustn't respond to particular views about a religious group feeling intimidated or attacked at a particular point in time. You should look at it over time. And over time, I think that the definition that we have, with the changes that have been discussed, or the broadening rather than the narrowing, is where we should go as a country. Not in an unreasonable way, and not to, overly, we've discussed that obviously something to be categorised as a terrorism offence is a very serious thing, and it brings with it additional powers of investigation, which I think in the nature of what we are seeing is very important. That is one of the key advantages of at least having something initially tagged as a terrorism act, so that it can be properly investigated. Even if at the end of the day we discover that it's being directed by outside people and local players don't have that intent, and the actual act is not prosecuted as such, but at least the investigation has the powers to get to the bottom of that. So there's that investigation part of also not narrowing the definition. So I think it's very important. And similarly, and we haven't discussed this, and there's I don't have the evidence to hand, but as we go into more and more of artificial intelligence and technology and what is coming online, I think there are more influences out there to cause people to conduct lone wolf acts or etc. The Director General of ASIO himself has warned that more Australians are being radicalised more quickly, and more of them online. So that is a whole era that we're seeing already in terms of anti-Semitism online that's dramatically increased, but other hatreds. And so I would urge you to, as I said, take a slightly longer view and not look at particular issues right now, but at not narrowing the definition. I think that it served us well, and there are such challenges that we see coming down the pipe in the not too distant future that I would urge you not to narrow it, but in fact to extend it in the small ways that we've spoken of in terms of serious psychological harm and hostage taking. Thank you.
Thank you. And again, thank you all very much for joining us today and for your submissions and your continued engagement with this review. There's a lot to think about in this session. You've put some very strong views and some constructive suggestions. We'll take away those and think about them. So thank you again for joining us. And we will be resuming shortly. We'll be back at 10:55 for our next session. Thank you very much.